eyes now, but I know there's always a way. From sunrise till dawn, I'll be here waiting. From sunrise till dawn, I'll never stop. I'll fix you up, make everything much smoother again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. The connections might be tangled, the power source has lost its spark, but every wire tells a story, and I can mend what's torn apart. From sunrise till dawn, I'll be here waiting. From sunrise till dawn, I'll never stop. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. When the current isn't flowing, when the signals disappear, I'll be here with tools and patience, make the static crystal clear. Every cable, every circuit, every problem that you bring, I'll restore what time has broken, make the whole world sing. So don't you worry about tomorrow, don't you stress about today. I've got maintenance for your troubles, and I'll chase them all away. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. Hey, Daniel, everything's good as new. Hey, Daniel, I'll fix you up for you.
Well, welcome to the show. Today it's a little something different. This is something out of the UK Supreme Court. I thought I would bring it to you just to see, just to watch and see what's different between us, the United States Supreme Court, and the UK Supreme Court. So let's get this started. And let's make this bigger.
A mouse is a principle of general application in that any mouse with such characteristics will cure the immunological sickness which afflicted the prior art mice, and so more efficiently produce the antibodies. The third matter I want to mention is that, as at the priority date, a person with skill in this field could make a transgenic mouse using the information disclosed in the patent and using their common general knowledge. And that's the finding of the Court of Appeal. If I could take the court back to the Court of Appeal judgment in Core Volume 2, Tab 2, it's paragraph 264 at MS page 238. And the court says, it summarizes its conclusion at 264, for the reasons we've given, we are satisfied that the skilled team could have produced transgenic mice within the scope of the claim without undue effort at the priority date, and that such mice would have had a near wild type response. And the reason why they reached that conclusion appears in the preceding paragraphs. They summarize at paragraphs 257 and 258 the two methods of making transgenic mice within the scope of the claim. There's the mini-gene approach that's dealt with in greater detail at paragraphs 153 and 187. And there's the obvious, as they saw it, obvious modification to example 3 in the patent, and that's dealt with at paragraphs 206 to 7 and 261 to 263. Now, those were the findings in respect of which Kymab sought permission to appeal to this court under its second proposed ground of appeal. And the court sees that in Core Volume 1 at page MS 35. There's a section under Ground 2 beginning at paragraph 21 through to paragraph 36, where Kymab seek to appeal against precisely those findings of fact, and the court refused permission to appeal on that ground, as the court sees at MS page 52. It's tab 3, MS 52. Permission was granted on ground 1 only. My friend referred, Mr. Purvis referred yesterday to what Regeneron had or had not done as at priority date. But in our submission, the question is not what Regeneron did, but what the skilled person, armed with the patent and with common general knowledge, could have done as at priority date. And that's what the Court of Appeal made those findings in respect of. It is nothing to the point what Regeneron what Regeneron did or did not do at particular times. The Court of Appeal applied the right test and it concluded that the skilled reader could have made a mouse with the reverse chimeric locus using the disclosed information and common general knowledge in this field. The fourth matter that we draw attention to as either not being in dispute or should not be in dispute on this appeal is the proper construction of Claim 1 of Patent 163. Now, the terms of the patent claim with which the court is concerned are crucial because the test of sufficiency must be applied in our submission by reference to what the patent claim is. And there are many statements of authority to that effect. One, I hope, will suffice. It's Lord Hoffman in Lundbeck. The court's seen it already, but can I just remind the court what he said? It's Authorities Volume 2 at tab number 12, and the relevant passage is at MS 1255. If I could take, please, the court back to MS 1255, Volume 2, tab 12 of the Authorities. The relevant paragraph is paragraph 29, where Lord Hoffman, making his special guest appearance in the Court of Appeal in that case, says, in order to decide whether the specification is sufficient, it is therefore first necessary to decide what the invention is. That must be found by reading and construing the claims in which the inventor identifies what he claims to be his invention. And then he refers to the Exxon case where the Board of Appeal said, it is the definition of the invention in the claims that needs support. So can I invite the court, please, to go to the relevant claim? It's in Core Volume 2. It's behind tab 8, and it's at MS 416. And the court sees at MS 416 claims about a couple of inches down the page. And claim 1 is this. It says a transgenic mouse that produces hybrid antibodies containing human variable regions and mouse constant regions, wherein such mouse comprises an in situ replacement of mouse VDJ regions with human VDJ regions at a murine chromosomal immunoglobulin heavy chain locus, and an in situ replacement of mouse VG regions with human VG regions at a murine chromosomal immunoglobulin light chain locus. And that is the reverse chimeric locus. It is the replacement of the mouse variable regions with the human variable regions, and it is the retention in situ of the murine constant regions. That's all it is. That is the claim. It is a claim to a mouse which has the physical characteristics of the reverse chimeric locus. And the Court of Appeal addressed this claim in the judgment at paragraphs 125, thank you, 125 and 126, which appears on MS page 201, MS 201. Paragraph 125, claim 1 of the 163 patent is directed to a transgenic mouse in which there's been in situ replacement of the mouse VD and J regions on the heavy chain by human VD and J regions, and in which there has been an in situ replacement of mouse V and J regions on the light chain by human V and J regions. And then this, the claim contains no requirement that any particular size of DNA fragment is inserted or replaced, nor is there any limit to the number of steps by which the claim requirements may be met. Further, the reference to V, D, and J regions must mean one or more V, D, and J segments, respectively. So that's what the Court of Appeal said about the construction of the claim with which this court is concerned, and in respect of which this court is seeking to identify what are the requirements of sufficiency. And it is...
Would you not have to read also paragraph 127,
yes,
where the judge appears to be accepting, where the Court of Appeal appears to be accepting what the judge found at paragraph 186?
127, as the judge explained, the following further points may be made about the scope of this claim. The claim is not confined to a single product. It includes mice in which different amounts of mouse V, D, and J regions of the heavy chain and mouse V and J regions of the light chain have been replaced by human V, D, and J regions and V and J regions respectively. So it includes, for example, a mouse in which one V, one D, and one J region of the heavy chain and one V and one J region of the light chain have been replaced, and mice in which several such regions have been replaced. It includes products over the page in which 100 of endogenous sequence have been deleted, 200 to 300 have been inserted, products in which 150 have been deleted, 75 have been inserted, There's no requirement that LT-VEX or the MOA assay must be used. The expressions VDJ regions and VJ regions as used in this claim are broad and encompass the whole mouse and human variable gene loci. Accordingly, the claim extends to a mouse in which the entire murine variable gene locus has been replaced with the entire human variable gene locus. And I quarrel with none of that.
No.
But all of that is the consequence of the construction of the proper construction of the claim being, as the Court of Appeal said at 126, that there is no requirement that any particular size of DNA fragment is inserted or replaced, nor is there any limit to the number of steps by which the claim requirements may be met. And 127 is drawing out, in my submission, the implications of that the claim relates to a mouse which has the defined physical characteristics, but the quantity of the DNA that is inserted and replaced is variable.
Might there not be importance in the very first sentence of 127, little one?
The claim is not confined to a single product. Well, I respectfully agree with your ladyship. Part of the difficulty in this case is to identify what is the product. And our submission is that here we are dealing with a mouse that has defined physical characteristics. The claim is to a mouse which has the reverse chimeric locus, irrespective of the quantity of the DNA which is inserted or removed. The claim is simply not concerned with that characteristic.
Well, it's not. One could say it's not a claim to a mouse. It's a claim to any mouse that has reverse chimeric loci. And that's why we're here.
It is, and the reason why it is a claim, the reason why it's defined in that way, is precisely because the technical contribution applies irrespective of the quantity of DNA which is inserted. It is irrelevant to the claim as defined. The claim is not to a specific quantity of insertion. It's not to particular means by which the DNA is inserted or taken out. It is a claim to a mouse which has the reverse chimeric locus characteristics. It's not even a claim to every way of curing immunological sickness in mice producing antibodies. That's not the claim. If there are other ways to cure immunological sickness, the patent does not apply to them. It doesn't affect them. So the point I'm seeking to make, is that if you look at the claim, the quantity of DNA, although it covers, as my Lord, the Deputy President has pointed out, my Lord the President is emphasising, although it covers an expanse, the definition of the claim is not concerned with that characteristic. It's not concerned with the quantity of DNA. It's not a claim to a range of distinct, discrete products, and this is an answer to my lady's question. It's not a claim to a range of distinct, discrete products. The mouse that falls within the scope of the claim must always have the same essential characteristics, and the same essential characteristics are the reverse chimeric locus. Why do I say essential? Because the size of the insert is simply irrelevant to the claim. It's irrelevant because the technical contribution is not affected by the size of the inserts. The size of the inserts in our submission is as irrelevant to the claim as drafted and as irrelevant to the technical contribution as the colour of the mouse or the length of the mouse's tail.
But Willie, the core issue here is that the claim is to any mouse with the particular characteristic. For that to be valid, one would ordinarily expect you to have enabled the making of any mouse with that characteristic.
Your Lordship says one would expect, but in my submission,
That's the ordinary rule.
That's the question of law is whether that is a universal requirement or whether the concept of enablement recognizes that where you have a claim of a particular type which relates to a product which contains essential characteristics which achieve a technical effect across the scope and irrespective of the divergence that we're focusing on, that is the quantity of DNA inserted, it is still necessary to show, as at priority date, that you can physically make every mouse. And our submission is to the contrary for reasons I'm coming on to.
Yeah.
I mean, it really it develops into the general principle argument, which is the key.
Yes,
Yes.
and I recognise, of course, that under the case law, in a normal case, not concerning a principle of general application, enablement has that consequence, but there are exceptions. And I shall seek to show the court that where one's dealing with a principle of general application, that is a product as here, with a combination of features which achieves a technical effect, and where you're claiming such a product and nothing else, then you do not need to show that every mouse that falls within the scope of the claim can be made as at priority date, because the differences in each of those mice are irrelevant to the claim, because the claim is nothing to do with the size of the insert. And it's irrelevant to the claim because it's irrelevant to the technical contribution that the claim makes. That's why it's drafted in that way. So,
I asked yesterday Mr. Purvis whether he submitted or accepted that what you call the contribution, namely the immunological benefit of the reverse chimeric locus, wasn't in fact part of the claim, and I think he agreed with that. Do you agree with that as well?
yes, because a claim usually, not always, but it usually focuses on the physical features. And it's not essential, far from it, to write into the claim the effect. The rest of the patent does that, but it's not necessary to put in the claim the technical contribution that you are claiming by way of effect. And it can't make any difference in my submission if one had added to claim 1 the words with the result that the immunological sickness that afflicted prior art mice is avoided, and therefore human antibodies are more efficiently produced. That's not the claim, that's the effect. But it is the technical contribution. The technical contribution in terms of the effect is the consequence of the reverse chimeric locus, which is set out in the claim. So I emphasise those points, that one's got to look at the claim, and the claim simply is not concerned with the feature which is being emphasised by my friends and which is the subject of discussion with the court. The claim is simply not concerned with how much can be inserted. One further point that follows on from this, my Lord the President asked yesterday about paragraph 259 of the Court of Appeal judgment. Could I invite your Lordships, your Ladyship, please to go back to paragraph 259. It's on MS 238. And it's the passage to which my friend drew attention in 259. It's the second sentence. We recognise there was a perception at the priority date that the greater the number of human V gene segments that had been inserted into the transloci, the more varied the human antibody expression was likely to be. And that was the sentence your Lordship asked about. We emphasise the next sentence. Nevertheless, as we've also seen, a transgenic mouse of this kind with only a few human V gene segments would have had an immunological response which was close to that of the wild type mice. And that is important because the point, again, is that the claim is not concerned with the diversity of the antibodies that are produced. The claim focuses exclusively on the reverse chimeric locus, that is, a mouse with the stated physical characteristics, because that mouse makes the technical contribution by curing the immunological sickness of the prior art mice. The prior art mouse had the immunological sickness which prevented the efficient production of antibodies, however many V's, D's and J's were inserted. The claim is not a claim to diversity of human antibodies. And that's why, in my submission, the sentence that my friend drew attention to is not relevant to the issue that the court is determining. Now, the significance of the issue before the court is that if Kymab is correct, it would not be possible to patent a keystone invention of this nature. By keystone, I mean in the sense that there can be later inventive improvements in the application of this invention, new methods for inserting larger quantities of DNA, but which use this invention, that is the reverse chimeric locus, retaining the murine constant region and inserting the human variable region. It would not be possible for the inventor of this keystone invention to gain a reward for the technical contribution, however significant it is. It would only be possible on Kymab's approach to patent specific means of implementing the patent that were available as at priority date, notwithstanding that later technical developments build on the keystone. And this raises, in our submission, an important issue about the policy basis of patent law, questions which my friend has chosen to keep for reply. But let me put my case to the court. Our case is that the patent system is designed to provide an incentive to publish a technical contribution in exchange for receiving an appropriate monopoly. And there are, of course, considerable public interest benefits in this. The information is made available to the world immediately. It's in the public domain. It can be used, of course, on the expiry of the patent. And if the monopoly which the state grants is narrower than the scope of the technical contribution, the incentive to apply for the patent is removed, or it's at least substantially reduced. The patentee would then have an incentive to keep his or her invention secret, rely on the law of trade secrets. All of this is fundamental. Whereas here the patentee has invented and has disclosed this keystone principle of general application. That is the product which is the subject of the claim. And where the mouse can be made in practice as at priority date, not, I accept, because these are the findings, not in respect of all quantities of insertion, but the mouse can be made using the reverse chimeric locus in practice as at priority date, then we say that the patentee must be allowed to claim the extent of its technical contribution to the art. And the problem is that due to the limits of DNA handling techniques at the time, that is, as at priority date, it was on the findings of the Court of Appeal only possible, without undue effort or inventive skill, only possible to insert DNA of up to a certain quantity. And if our patent protection were to be limited, as Kymab are submitting, to a reverse chimeric locus of that size, that quantity of DNA, especially when the claim has nothing to do with quantity, then patent protection would effectively be lost as soon as the DNA handling techniques improve to allow for the manipulation of slightly larger quantities of DNA. When that occurs, according to Kymab, as soon as the handling techniques improve, so you can insert larger quantities of DNA that you couldn't insert as that priority date, then, according to Kymab, they and every other competitor are entitled to use Regeneron's technical contribution, that is the reverse chimeric locus. They're entitled to insert, using the reverse chimeric locus technique, even though that technical contribution to the art was novel, was inventive, and was not concerned with the amount of the DNA that is inserted. That's what this case is really about. And our submission is that that would simply frustrate, with great respect, it would frustrate the policy basis of patent protection.
Very old problem, isn't it? I mean, if one thinks about the Edison case in the US Supreme Court, I mean, one might say that the inventive step there really was the whole idea of using interruptions in an electric current over a very long distance as a means of communicating over long distances. But he wasn't allowed, as it were, to patent the idea. He could only patent the particular technology that he'd devised.
Well, it is an old problem, and the answer to it is going to depend upon the particular facts of the particular case, not least what is the claim. And I've accepted that, of course, there has to be not just an idea, it has to be something that we can show as at priority date works in practice. But what is so striking in my submission about this case is that the point that is taken against us is a point based on an inability, as at priority date, to implement the claim in relation to larger inserts of DNA, when that feature has absolutely nothing to do with the content of the claim or the technical contribution that is made by the patent. We say in those circumstances, the Court of Appeal was absolutely right to point out, it's paragraph 260 of the judgment, MS 238. It's the final sentence of that, after they've set out that the character of the invention is one of general application. The final sentence of paragraph 260 on MS 238, what is more, there's nothing in the claim which could have been envisaged without the invention, and were protection to be limited to only those embodiments which could have been made at the priority date without undue effort, the protection provided by the patent would have rapidly become ineffectual.
I wonder if trying to sort of relate the case being made against you to your description of the patent bargain, I wonder if it might be described in this simple way, that you can't get a monopoly over the making of something if neither you nor the rest of the world can, at the priority date, make that thing with the combined assistance of the then available public state-of-the-art and your teaching.
Well,
in other words, what you have to put into the public domain is an ability to do precisely that with your teaching, but for your monopoly, they could go away and do.
Yeah. But of course, in this case, on the findings of the Court of Appeal, the reverse chimeric locus could be made to work in practice using the two examples that the Court of Appeal gave. This is not a case where, as at priority date, the mouse could not be made, could be made. What couldn't be made is a mouse using quantities of DNA more than a specified, or not specified, because the Court of Appeal never specified, but a certain amount.
Not all the types of mouse within your claim as properly construed by the Court of Appeal.
I would respectfully, that's where I would respectfully dispute what your Lordship puts to me, because what could be made is a mouse with the reverse chimeric locus. What could not be made is a mouse with each and every quantity of DNA that the claim extends to. And the question for the court is whether that is central to the law of sufficiency. And my submission is you've got to look at the claim, you've got to look at the technical contribution, which here is not dependent on the quantity. And this is the content of the current submission, one needs to consider public policy arguments, because that's what the cases emphasize, that it is vital in the law of sufficiency, as in all other aspects of patent law, that the scope of the patent protection is commensurate, that's what he said, is commensurate with the technical contribution. And if Kymab are correct on this appeal, it is not the case that the scope of our patent protection is commensurate with our technical contribution. On the contrary, our technical contribution cannot be protected. It simply cannot be protected. My Lord the President asked my friend yesterday afternoon if Regeneron could have patented the method rather than the product. And there are two difficulties with that. The first difficulty is that the technical contribution is the mouse with the specified features. It's the product. But more important, my submission, than that is that the same problem would arise if one attempted to patent the method. Kymab would say that we can't patent the method generally because at priority date only some examples could be made. So the same point would arise. That would be their submission. If we had said, well, this is a method of making a mouse to produce antibodies, Kymab would say, well, you can patent a method, but only if you can make it as at priority date. And what you could have made was only a mouse with an insert of up to a certain amount of DNA. So the problem doesn't go away. The problem is simply repeated in that context. So that's no answer. My friend, as I've indicated, said very little about policy, but he asked rhetorically the question, why should Regeneron be able to patent A to Z when, as at priority date, only A and B could be made to work? That was his rhetorical question. And in my submission, the analogy breaks down because it ignores the fact, the crucial fact, that there is here a principle of general application. The analogy wrongly suggests that there are 26 different mice here. But the claim is to a mouse with defined physical characteristics. That is the physical feature of the reverse chimeric locus, irrespective of the size of the inserts. It is true, and of course I accept, that that means a claim to a mouse with inserts A, B, C, up to Z. But the size of the inserts, as I've said too often, is irrelevant because the claim is not concerned with that feature. And it's not concerned with that feature because the technical contribution does not depend in any way on that feature.
If I may say so, that seems a bit circular. I mean, you say, well, we've defined the claim in completely general terms, and so it doesn't matter that some mice that answer that description might be physically different and more valuable than other mice that answer that description because those particularities aren't specified in the claim.
But we're not I take your lordship's point, but we're not defining the claim in those terms for some arbitrary reason or in order to gain an unmerited advantage. We're defining the claim in those terms because that is the technical contribution. And the technical contribution simply does not depend on the size of the inserts. The size of the insert is irrelevant on the findings to securing the curing of the immunological sickness. The prior art mice were sick, irrespective of how much DNA you insert, and the reverse chimeric locus mice avoid the immunological sickness irrespective of how much DNA you insert. So it's, in my submission, it's not circular. It is to start, as Lord Hoffman says, with what is the claim. And in my submission, to recognise that the claim is defined in those terms for a perfectly proper, valid reason. That's the point in my submission of this case. So our policy argument is that for Kymab to succeed would frustrate the basic principle of patent law, which applies in the law of sufficiency as it applies elsewhere, see Actavis, and see Lord Assumption in the generics case, and the court should be very slow to arrive at a conclusion, in my submission, manifestly contrary to the basic aims of patent law by denying my clients the reward for the inventive contribution which they have disclosed. They've disclosed it in full. Now, my friend, as I've said, hasn't addressed this, but the point was put to my friend Mr. Tappin in argument in the Court of Appeal. And the court may just wish to have in mind what was said in argument. It's in Appendix Part 2, Tab 6. And it's MS 749. And both Lord Justice Kitchen and Lord Justice Floyd asked Mr. Tappin about this. And at MS 749, if the court has the top left-hand page, that's page 335, at line 17, Lord Justice Kitchen says this: he, that's Regeneron, has come up with reverse chimeric locus which works for any insert, but he cannot get protection for it. Mr. Tappin, as I say, I'm not going to say whether he can or can't get protection for it, or how he should draft his claim to get protection for it, because they will be writing it down and saying, you said that was good enough. But so I'm not going to do that. It may be you can draft a set of claims which do achieve what he wants to achieve, but it's not these. Lord Justice Kitchen, this is page 336, it's very hard to see how one can do it. Mr. Tappin, good. And then at the top of page 337, still on MS 749, in line 5, Lord Justice Floyd says this: the oddity is that as soon as your patent is published, someone who's sitting on a technique for making large inserts, who's not had this idea at all, that's the reverse chimeric locus, but which would work to make the reverse chimeric locus, gets a free license to Regeneron's invention. It's not a license, but he gets free use of the Regeneron invention simply because he's made a different invention. That does not instinctively seem right. Mr. Tappin, I do not know, etc., etc. And I draw attention to that because my friend has simply not addressed these absolutely vital features of this case. Kymab, in my submission, have no answer to the concern that the policy basis of patent law would be undermined if a person in the position of Regeneron had no way of protecting their technical contribution. The inevitable consequence would be a reluctance to invest in the development of innovative technology of this sort, or to the extent that such investment were made, a reluctance to disclose it in a patent application, or to disclose it later when you've worked out the practical implementation of all, or substantially all, of the implementations. Here, the technical way of getting large quantities of DNA into the mouse. That would delay the public having this information. It would delay the end of the monopoly, and it would have all of these adverse consequences. We say those are important features of this case, which we ask the court to bear in mind.
Can I just ask you, if the technical contribution is actually the idea, and you had the idea, but no way of putting it into practice, as was thought to be the case, I think, at first instance, then you can't have a valid patent. So somebody does get into the position which is being spoken of by Lord Justice Floyd, where they can use your idea and apply their greater science to put it into practice.
Yes. Well, if you simply have an idea which has no practical application at all, then the patent system gives you no protection because it's a purely academic, theoretical concept.
So that demonstrates that it's not the idea, it's how you formulate the manifestation of the idea.
Well, in my submission, what it demonstrates is that you have to show that there is a practical implementation. It doesn't answer the question whether it is sufficient in a case of this sort to be able to show one practical implementation or all of the practical implementations. It doesn't show that. And the case law, which I'm coming to now, recognizes that it is not a requirement where you have a principle of general application, that you must be able to show as at priority date that all of the applications can be implemented in practice. There are cases, we say this is one of them, where it's sufficient to show one implementation and that the idea, the concept will work across the board, whether or not you can actually implement it as at priority date. So can I turn to the case law? There's, of course, the domestic case law, there's the EPO case law, and the two overlap because the domestic cases rightly have regard to the EPO jurisprudence. And it is, we say, very important when one analyses the cases on sufficiency to bear in mind in each case the nature of the invention, the nature of the claim, because many of these cases concern a technical contribution of narrow compass and a claim which impermissibly seeks to claim broadly. That's what many of the cases are all about. First, the domestic case law, starting, and I'll take this briefly, not least because my friend Mr. Smith has more to say on this. Can I just identify some passages of relevance? First, Biogen, and picking it up in the Court of Appeal, which is volume 1 of the authorities, tab 4, at page 9, MS 913. This was the passage that the court looked at yesterday in the judgment of Lord Justice Hobhouse, MS 913. And picking it up in the penultimate paragraph, line 38, Lord Justice Hobhouse says this: the disclosure must be sufficient to enable the whole width of the claimed invention to be performed. What will suffice to satisfy this criterion will vary depending upon the nature of the claim that has been made. It is essential to apply the test having regard to the extent of the claim. It is not the law that the disclosure of a single embodiment will always satisfy the requirement regardless of the width of the claim. And we respectfully agree, it's not our case that disclosure of a single embodiment will always satisfy the requirement. But Lord Justice Hobhouse is recognising that there will be cases where that is so. Mr. Laddie then made his submission, and it fails on the facts for the reasons given by Lord Justice Hobhouse, summarised at lines 45 to 50 and dealt with later. But he's not rejecting the...
Well, what he's endorsing, line 37, what the board has said correctly represents the law. Well, what it said at line 30 is that disclosure of a claimed invention is only sufficient if it enables a skilled person to obtain substantially all embodiments falling within the ambit of the claims.
And this is a quotation from Exxon, which we'll go to, and we'll see that Exxon distinguishes between different types of case, and it's not there dealing with principles of general application. The passage that I've drawn attention to has the meaning for which I respectfully contend. Then we move to Lord Hoffman speaking for the appellate committee in Biogen. That's the next tab. And Biogen, of course, was a case in which the monopoly claimed extended beyond the technical contribution of the patentee. And can I pick it up? Your lordships and ladyship have seen some of this. Can I pick it up at page 48? And there's the sentence at the top of page 48. It's MS 979. MS 979, top of page 48 of the report. Lord Hoffman says what has been less clear is what the concept of an enabling disclosure means. And that's the issue in our case. What does enabling disclosure mean in these circumstances? He goes on, part of the difficulty is being caused by a misinterpretation of what the Technical Board of Appeal of the EPO said in Genentech polypeptide expression. This was a patent for a plasmid suitable for transforming a bacterial host, which included an expression control sequence, or Regeneron, which would enable the expression of foreign DNA as a recoverable polypeptide. The examining division was willing to grant a patent only in respect of the plasmids, bacteria, and polypeptides known at the date of application. The patent extended far broader than that. It extended to a whole range of different plasmids, bacteria, and polypeptides. The Technical Board of Appeal allowed the appeal, saying that the examining division had taken too narrow a view of the requirement of enabling disclosure. In other words, that a patent in those circumstances was valid, even though it was not possible to make plasmids, bacteria, polypeptides that were within the scope of the claim. And that is fundamentally inconsistent with the submissions that Kymab are making. Lord Hoffman then cites from Genentech, and I'll come back
when you say they couldn't be made, Lord Hoffman just seems to be saying they weren't known at the date of the application.
Yes, but because they weren't known, they couldn't be made.
Well, except that if you read what he says after the quote,
In other words,
if there was no reason to believe it wouldn't work equally well with any plasmid, bacterium, or polypeptide.
indeed, and that is our case. There is no reason on the findings of fact to doubt that the reverse chimeric locus will not work with any quantity of DNA inserted. The problem is that you can't physically insert all of the quantities of the DNA in our case. In Genentech, you couldn't produce all of the polypeptides which were within the scope of the claim. In that case, because they were not known as at the date, as at the priority date. But the point Lord Hoffman draws from this case, he says, in other words, the applicants had invented a general principle for enabling plasmids to control the expression of polypeptides in bacteria, and there was no reason to believe that it would not work equally well with any plasmid, bacterium, or polypeptide. The patent was therefore granted in general terms. And those words, and there was no reason to believe that it would not work equally well, do not mean, cannot mean, there was no reason to doubt that the patent could be made to work in practice as at the priority date, because it couldn't. What he's saying is that across the scope of the claim, the patent, the technical contribution, the general principle will work. It is scientifically effective. And it is therefore, he says, where you have a general principle of this nature, it is no basis for denying the claim, for finding insufficiency, that you cannot show that the claim can be made to work as at priority date across the scope of the claim. And he then deals at line 40. In fact, he says the board in Genentech was doing no more than apply a principle of patent law which has long been established in this country, namely that the specification must enable the invention to be performed to the full extent of the monopoly claimed. If the invention discloses a principle capable of general application, the claims may be in correspondingly general terms. The patentee need not show that he has proved its application in every individual instance. On the other hand, if the claims include a number of discrete methods or products, the patentee must enable the invention to be performed in respect of each of them. So there's a distinction between a principle, general principle, or principle of general application, and cases where your claim is to discrete methods or products. And that's what we rely upon. Lord Hoffman goes on at the top of 49, thus if the patentee has hit upon a new product which has a beneficial effect but cannot demonstrate that there's a common principle by which that effect will be shared by other products of the same class, he'll be entitled to a patent for that product but not for the class, even though some may subsequently turn out to have the same beneficial effect. On the other hand, if he's disclosed a beneficial property which is common to the class, he'll be entitled to a patent for all products of that class, assuming them to be new, even though he's not himself made more than one or two of them. So that's the distinction that Lord Hoffman is drawing, and he draws it by reference to Genentech. And in the next paragraph, Lord Hoffman, does not regard Exxon fuel oils as contradicting those principles. Since Genentech, the EPO has several times reasserted the well-established principles for what amounts to sufficiency of disclosure, and he mentions Exxon fuels, to which I will return. So that's what I rely on in the Genentech case. And next, can I take the court to Kieran Anjan? And the court will find this in Authorities Volume 2, tab 16, MS 1536. Tab 16, 1536, Lord Hoffman for the appellate committee. And in this case, the principal issue was whether Kieran Anjan's patent claims properly construed extended to the defendant's process and products, and that was an issue of construction. And a subsequent question was if the patent claims did cover the defendant's product and process, whether the claims were bad for insufficiency. And Lord Hoffman turned to that question at MS 1567, and at paragraph 103, Lord Hoffman said, similar to what he said in the Lundbeck case later on in the passage, paragraph 29, that I've already referred to this morning. He says at 103, whether the specification is sufficient or not is highly sensitive to the nature of the invention. The first step is to identify the invention and decide what it claims to enable the skilled man to do. Then one can ask whether the specification enables him to do it. And at MS 1568, there's a heading above paragraph 110, breadth of claims. He says, if your lordships agree with my view on construction, the appellate committee do not cover the defendant's process, and the specification need not enable it. So this is obiter. And about 10 lines down, Lord Hoffman says, the Court of Appeal, for whom the question did not arise, was inclined to agree with the judge. Lord Justice Aldous said, the law contemplates that patents will not lack sufficiency, even though the claims cover inventive improvements. If the law was otherwise, there would be no room for patents which disclosed a principle of general application unless the specification described how to carry out later inventions using the principle. And we rely on that. We say that's absolutely right. It accords with all the policy considerations to which I have drawn attention. At 111, Lord Hoffman says, as the question did not arise for your lordships, I do not propose to express a concluded view. Nevertheless, Lord Hoffman can't resist giving a view, and at 112 on MS 1569, his lordship says, this gave rise to a great deal of argument about what amounted to a principle of general application. In his lordship's opinion, there's nothing difficult or mysterious about it. It simply means an element of a claim which is stated in general terms. Such a claim is sufficiently enabled if one can reasonably expect the invention to work with anything which falls within the general claim. For example, in Genentech, the patentee claimed in general terms a plasmid suitable for transforming a bacterial host, which included an expression control sequence to enable the expression of exogenous DNA as a recoverable polypeptide. The patentee had obviously not tried the invention on every plasmid, every bacterial host, or every sequence of exogenous DNA, but the technical board of appeal found that the invention was fully enabled because it could reasonably be expected to work with any of them. And that does not mean that it could be made to work in practice as at priority date, because that was the whole basis of the concern in Genentech, that it covered even applications that had not yet been contemplated. Lord Hoffman returns to the point at 117, that is Lord Justice Aldous' point. As for the point made by the Court of Appeal, it is of course correct so far as it goes. The choice of a particular form of an integer falling within the terms of the claim may improve the way the invention works and be in itself an inventive step. The specification is not insufficient merely because it does not enable the person skilled in the art to make such an invention. The use of the improvement is still a way of working the original invention. But TKT does not rely upon the fact that the use by TKT of an endogenous EPO gene was invented. Their objection is that it was not a way of making EPO, which is disclosed even in the most general terms by the specification. So again, paragraphs 112 and 117 recognize in my submission that where one has a principle of general application, it is not necessary to show that as at priority date, the invention can be made across the scope of the claim. It is enough, it is sufficient to show that the invention, the claim can be worked in at least one embodiment, and that the claim can be expected to work across the scope of the claim. That's my submission, that's the test that Lord Hoffman is there setting out. Then we come to Lundbeck, where Lord Hoffmann in the Court of Appeal returned to the subject. This is tab 12 of the same volume. Picking it up, I've referred to paragraph 29, and if I could invite the court's attention to MS page 1256, at paragraph 34, and in paragraph 34, it's the third sentence, but the law of sufficiency, both in the United Kingdom and in the EPO, is that a class of products is enabled only if the skilled man can work the invention in respect of all members of the class. The specification might show that this has been empirically demonstrated, or it might disclose a principle which can reasonably be expected to apply across the class. And he cites a number of cases. They include Genentech and Kirin Amgen and also Exxon. And the problem he identifies in Biogen, the specification in Biogen described only one method of making the molecule by recombinant technology and disclosed no general principle. It was easy to contemplate other methods about which the specification said nothing and which would owe nothing to the matter disclosed. And those are the crucial words. If Kymab or anybody else does something which owes nothing to the matter disclosed, in other words, they don't use the reverse chimeric locus, then the patent has no application. But where there is, says Lord Hoffmann, a general principle, that is that it is here a mouse with defined physical characteristics which can reasonably be expected to apply to have the effect across the class, then the patent is sufficient and it applies in circumstances where what is done owes a substantial amount to the matter disclosed. To say we're making a mouse with a reverse chimeric locus, but with a larger quantity of inserts, owes substantially to the matter disclosed. So we rely on paragraph 34. Paragraph 35, to which again I think my Lord the President drew attention yesterday, begins, in my opinion, therefore. So Lord Hoffmann is reminding himself of what Biogen was all about. Biogen was about a claim that was too broad in the sense that it purported to cover other methods of making the molecule distinct from that which had been disclosed and for which there was the technical contribution. In my opinion, therefore, the decision in Biogen is limited to the form of claim which the House of Lords was there considering and cannot be extended to an ordinary product claim in which the product is not defined by a class of processes of manufacture. And Lord Hoffmann puts it in that way because of the nature of the issue that arose in the Lundbeck case. And the issue is most helpfully summarized in my submission. The issue that Lord Hoffmann is there addressing is most helpfully summarized in the appellate committee in Lundbeck, which is the next tab, tab 13, at MS 422 by Lord Mance. This is what the case was about, paragraph 41. The issue, this is MS 1277. The issue on this appeal is short, though fundamental. Where a patent claim relates to a product rather than a method, is the patent liable to revocation on the ground of insufficiency under section 72(1)(c) if the only invented step involved in the product consists in the method by which it is made available, and if its description and specification disclose only that invented method, and superior methods are found by others which owe nothing to that method. Can such a claim be said to have been supported in its full width by the description given in the sense identified as necessary by Lord Hoffman, giving the main speech in Biogen? And the appellate committee, like the Court of Appeal, held that the test of sufficiency was satisfied in those circumstances. Particular circumstances, particular details don't, for my purposes, matter. But that's why that's what Lord Hoffman is addressing at paragraph 35.
But in our case, the inventive step is not the method by which the product's made available, it's rather the product itself.
Yes, that's our case. It is a product with defined characteristics, accepting, as I do, that product with defined characteristics extends to different quantities of DNA inserted, but in circumstances, the court has the point, where that is not the claim, it's not material to the claim, it's not material to the claim because it's irrelevant to the technical contribution. So I say Lord Hoffman here is not purporting to resile in Lundbeck from what he said twice in Biogen and in Kirin and Amgen. Lord Hoffman's view for the appellate committee is that there is a class of case where the claim is to a principle of general application, where that is the technical contribution. And in such cases, the law of sufficiency does not require the patentee to establish as at priority date that each application within the scope of the claim could be made. It is sufficient to show that an embodiment could be made, as is here the case, and that there is no reason to doubt, or it's reasonable to expect, it's put different ways, that the principle of general application will work, in the sense will be effective, across the scope of the claim. Not that it can be performed as at priority date, but that it will work, the technical contribution will work across the scope of the claim. And that is entirely consistent, in my submission, with the policy aims of patent law, and it is what Lord Hoffman repeatedly says and does not resile from. My friend drew attention to the Novartis and Johnson case. Can I just mention that? That's volume 3 of the authorities, tab 21. Novartis and Johnson, and that's MS 1833. And my friend drew attention to the passage at MS 1852, where after citing from the plant gene expression mycogen case in the Board of Appeal, at paragraph 74, Lord Justice Jacobs says the heart of the test is, can the skilled person readily perform the invention over the whole area claimed without undue burden and without needing inventive skill? Now, this is not a case that is concerned with the requirements of the law of sufficiency in the context of a principle of general application. We see that from earlier in the judgment. If I invite the court's attention to MS 1848, paragraphs 50 and 51, Lord Justice Jacob was dismissive, no doubt appropriately so, of what was being claimed in that case, MS 1848, paragraph 50. So we come to an astonishing conclusion. Although the claim has a number of elements, hardly any of them have any significance. The claim is to a lens made from a polymeric material consisting of two vast classes of polymerizable materials, one having high oxygen diffusion rate, the other having a high ion or diffusion rate. In substance, the claim amounts to this. If you try any pair of polymers to see if they work and find anything that does, we claim it. What help does the teaching of the patent give the reader to find a combination of polymers which works? The answer is again astonishing, hardly anything, notwithstanding the length of the disclosure, etc., etc. So that's the context and the conclusion reached by Lord Justice Jacob on MS 1857, paragraph 92. His Lordship concludes with the agreement of Lord Justice Patten and Lord Justice Ward. The upshot of all this is that the judge was entirely right to decide that the patent was insufficient. It is no more than a, quote, if you can find it, we claim it, unquote, patent. Its avaricious ambit, coupled with its failure to provide any help, makes it nothing but a hazard to those conducting research into extended wear contact lenses. So Lord Justice Jacob wasn't very impressed. That's the context, and in my submission, it tells the court absolutely nothing about the principles in a case where there is a principle of general application. The other domestic case that I want to mention is Generics and Warner-Lambert, which is in volume 4 of the authorities at tab 27. And it's at, starts at MS 2065. And my Lord the Deputy President and my Lord the President were members of this court, and also my Lord Briggs. And the court will remember that the case concerned how the law addresses second medical use patents, what my Lord Briggs described at paragraph 90 of my Lord's judgment at MS 2125 as it being a difficult appeal. And the difficulty, the court will recall, is how does the law address second medical use patents, that is where the invention consists not of a new process or a new product, but a new therapeutic purpose for an established pharmaceutical product. That was the context. And Lord Sumption gave the lead judgment with which my Lord the President agreed, and my Lord Briggs agreed with Lord Sumption on the test of sufficiency. That again is paragraph 90 at MS 2125. My Lord the Deputy President and Lord Mance adopted a test more favourable to the patentee on sufficiency, as I'll mention in a moment. So can I focus first on Lord Sumption's judgment for the court? Paragraph 17 on MS page 2098 contains the general statement as to the objectives of patent law that were approved and developed by my Lord the Deputy President for the court in Actavis. Indeed, my Lord quotes from that, so I won't repeat it other than to highlight the final sentence of paragraph 17, as I've already done, that the law of sufficiency is one of the parts of the of patent law that is directed to the same principles and policies. So that's paragraph 17. Lord Sumption explained at paragraph 20 MS2099, at the bottom of MS2099, the last three lines, that Mr. Justice Arnold and the Court of Appeal concluded it was not enough simply to refer to a known compound and assert that it was efficacious for treating a specified condition. The patentee must disclose some reason for regarding this assertion as plausible. So that was the origin of the question that was raised in this case. What was the test for disclosure in this second medical use context? Lord Sumption then refers to a number of judgments, or rather decisions, in the Board of Appeal. And there's a passage I want to mention at MS 2106, paragraph 35, where Lord Sumption says of the decisions or judgments of the Board of Appeal, 2106, paragraph 35, all of these judgments deal with highly fact-specific issues arising from objections or potential objections on the ground of insufficiency. When reading them, it is important not to miss the wood for the trees, and we respectfully invite this court to have regard to that when looking at the Board of Appeal's decisions. The fundamental principle which they illustrate is that the patentee cannot claim a monopoly of a new use for an existing compound unless he not only makes but discloses a contribution to the art. None of them cast doubt on the proposition that the disclosure in the patent must demonstrate, in the light of the common general knowledge at priority date, that the claimed therapeutic effect is plausible. On the contrary, they affirm it. And then the relevant paragraph is paragraph 37, because Lord Sumption addresses what plausibility means in this context. And his lordship says plausibility is not a term of art. Its content is inevitably influenced by the legal context. In the present context, the following points should be made. First, the proposition that a product is efficacious for the treatment of a given condition must be plausible. It's not made plausible by a bare assertion to that effect, and he cites an authority. Third, the claimed therapeutic effect may well be rendered plausible by a specification showing that something was worth trying for a reason, i.e. not just because there was an abstract possibility that it would work, but because reasonable scientific grounds were disclosed for expecting that it might well work. And then further down, about 10 lines, fourth, although the disclosure need not definitively prove the assertion that the product works for the designated purpose, there must be something that would cause the skilled person to think that there was a reasonable prospect that the assertion would prove to be true. Then he refers to the Salk case, and sixthly, he says this point was made in the context of experimental data, but the effect on the disease process need not necessarily be demonstrated by experimental data. It can be demonstrated by a priori reasoning. For example, and it's no more than an example, the specification may point to some property of the product which would lead the skilled person to expect that it might well produce the claimed therapeutic effect, or to some unifying principle that relates the product or the proposed use to something else which would suggest as much to the skilled person. Seventh, sufficiency is a characteristic of the disclosure. These matters must appear from the patent. Now, I cite that because although I recognize, of course, that the context is a different one, the context is second medical use, it is addressing the law of sufficiency, and it is an example of the law of sufficiency being satisfied by demonstrating in a scientific way that your product will, or rather can be expected to work across the scope of the claim, and it is not in that context, says Lord Sumption for the court, necessary to show in practice that it works across the scope of the claim.
Because that is talking about the test of plausibility.
Yes, it is. Yes, I entirely accept. That's why I recognise it's a different context, but it is an example of the law of sufficiency being satisfied in circumstances where the patentee has not established as at priority date that the invention, the claimed therapeutic use can be worked in a practical way across.
How far statements on the test of plausibility help? Because plausibility was a concession, if I recall, because the only way you could test these medical products was by public disclosure through medical tests, by which time your ability to claim a monopoly had gone. Well, so it's a slightly different context.
It is, and I readily accept that. My point is that the patent law is sufficiently flexible that it can accommodate a situation of the sort that my Lord the Deputy President refers to, without demanding in some absolutist manner that it's necessary to show as at priority date that something could be worked. That's the only point I'm making.
My problem is, Lord Panic, is in transferring these observations to this case, is that in that case, therapeutic effect was right at the heart of the claim.
Yes.
That's what the thing was all about.
Yes.
In this case, as I think you agree, therapeutic effect hasn't got anything to do with the claim. It's not part of what's claimed. It may be why the product is a good product. And I have real difficulty in when you say, well, there's a reason to suppose this is going to work. I think you're saying there's a reason to suppose that any mouse which has a reverse chimeric locus will be a healthy rather than a sick mouse. But that's an observation about therapeutic effect, not about whether you can make a reverse chimeric locus right across the scope which you claimed you can make it.
My only point about the generics case is it shows the ability of patent law to recognise the need for reasons of principle and policy not to apply in some absolutist manner across the scope of patent law relating to the test of sufficiency, a requirement which would frustrate the purposes of patent law. And in our case, your lordship is right, and indeed I've made this point. The claim is not a claim to therapeutic effect. It's the effect traditionally is not part of the claim; it's part of the patent. But one can't separate out the effect of the reverse chimeric locus from the question of sufficiency, because the effect is the inventive contribution. It's the technical contribution to the art. The technical contribution to the art, the significance, is indeed in the removal of immunological sickness. So I don't accept one can, in attempting to decide what is the scope of the test of sufficiency in this context, that one should ignore that feature. So I draw the court's attention to that case as we say helpful. The court will decide to what extent it provides assistance. Can I next turn to the EPO case law? And I make two general points of wood rather than trees, as Lord Sumption put it. First, that the EPO case law emphasises repeatedly that the requirements of the law of sufficiency very much depend on the circumstances of the individual case, in particular, the content of the claim, and whether the claim is to a principle of general application. And second, the EPO case law emphasizes repeatedly that the law of sufficiency seeks to ensure that the breadth of patent protection is commensurate with the claimant's technical contribution to the art. Can I start with Genentech, which is Authorities Volume 4, at tab 31, MS 2280. And the claim covered embodiments which could not be made as at priority date, but nevertheless the Board of Appeal held that the claim satisfied the test of sufficiency. And one finds this starting at 2292, MS 2292. At the bottom of the page, paragraph 3.11, recombinant plasmids embrace as components various regulons which have not yet been provided and may one day represent inventions on the basis of some merit of their own. The same applies to the basic plasmid, which has been modified to possess the characteristics of the claim. The original plasmid may have complex structures to be developed in the future. Bacteria transformed of the claimed plasmids embrace mutant or modified forms not yet known. According to the examining division, this situation contradicts the suggested requirement that all embodiments within the claims should be reproducible at will by the skilled person without having to make an invention. So that's the proposition that the examining division articulated. 3.12, there is, however, in the opinion of the board, no such principle, no such requirement in the EPC, nor is such principle established in normal patent practice within the contracting states. The suggested features in the claims are essentially functional terms in this particular context, in spite of structural connotations, and may cover an unlimited number of possibilities. It follows that the features may generically embrace the use of unknown or not yet envisaged possibilities, including specific variants which might be provided or invented in the future. And then the final paragraph on that page, or subparagraph, in appropriate cases such as the present, it is only possible to define the invention, the matter for which protection is sought under Article 84, in a way which gives a fair protection, having regard to the nature of the invention which has been described by using functional terminology in the claims. And we rely on all of that. There is no principle in all cases of the nature suggested by the examining division. It is crucial to identify and define the invention, and it is essential, says the Board of Appeal, to seek to give a fair protection having regard to the nature of the invention. That is our case. Then over the page, MS 2294, what is also important in the present case is the irrelevancy of the particular choice of a variant within the functional terms. It's not just that some result within the range of polypeptides is obtained in each case, but it's the same polypeptide which is expressed independent of the choice of these means. We rely on that. The claim is the reverse chimeric locus, which results in the lack of immunological sickness. 3.15, the above examples show that the need for a fair protection, again those words, governs both the considerations of the scope of claims and of the requirements for sufficient disclosure. And then the penultimate sentence on that page, thus it is the view of the board that an invention is sufficiently disclosed if at least one way is clearly indicating enabling the skilled person to carry out the invention. That's why we submitted that one way suffices in this type of case. Consequently, any non-availability of particular variants of a functionally defined component feature of the invention is immaterial to sufficiency so long as there are suitable variants known to the skilled person through the disclosure or common general knowledge which provide the same effect for the invention. The disclosure need not include specific instructions as to how all possible component variants within the functional definition should be obtained. And we also draw attention to
Sorry,
MS...
just so I can understand. So was the claim in this case to a product?
Yes.
And
So
so it's an example of a case where you have a product claim, you've shown one way in which the product can be made, and the board is saying that's enough for sufficiency for a product claim. You don't have to show all the other ways in which that product might be made.
Well, there's a whole variety of products, and there's a whole variety of plasmids which are being claimed. It's not a single plasmid. Yes, it's, thank you, it's 2283.
But the
Is which one? Yes, 2285 is the claim. Claims 1 and 9 to 13 worded as follows in the middle of the page. A recombinant plasmid suited for transformation of a bacterial host wherein the plasmid comprises a homologous regulon, etc., which is not degraded, the said DNA being positioned in proper reading frame, whereby on translation of the transcription product, the resulting expression product is said desired functional polypeptide or intermediate thereof in recoverable form. Then there's a process claim as well. And then number 10, thank you, on 2286, a bacterium transformed with a recombinant plasmid according to any one of claims 1 to 8. And the problem, said the examining division, is that this was sufficiently broad that there were products within the scope of those claims that could not be made as at the priority date. And what he said is that because what has been claimed and what has been disclosed is a general principle, that is not a fatal difficulty. And at 2298, in the middle of the page, MS 2298, in the first main paragraph, about 10 lines up from the end of, 12 lines up from the end of that paragraph, we're told the character of the invention this time is one of general methodology which is fully applicable with any starting material and is, as it was already stated, also independent from the known trivial or inventive character of the end products. Yeah.
makes it sound a bit like a process claim at heart. What I was wondering what the repeated reference in the key passages to functional terms were. And it looks as if from 2285, where the claim is actually set out, is that the question of what the product would do, would achieve, would lay absolutely at the heart of the claim, rather like a second medical use patent. They're saying this produces a stream of polypeptides. The polypeptides themselves, I don't think, were novel. What was novel was that you could introduce into a bacterium control mechanisms which would they always produce a certain stream of polypeptides.
Well, 3.13 at the top of 2294, what is also important in the present case is the irrelevancy of the particular choice of a variant within the functional terms bacteria, regulon or plasmid.
Yes.
It's not just that some result within the range of polypeptides is obtained in each case, but it's the same polypeptide which is expressed independently.
But the patent isn't the polypeptides. The patent is a process or a process and a product which produces a stream of polypeptides. In other words, its effect was right at the heart.
Well, it's a means of achieving a defined result, the production of a polypeptide, the chain of amino acids forming all or part of a protein. It's the means of doing so, but that's not, in my submission, great respect, a relevant distinction from this case, where the claim is to a product which has defined physical characteristics. And in any event, I would respectfully submit that the principle for which this case stands cannot depend upon any distinction along those lines. What the case is recognising, as they say well, they say unequivocally at 3.12, that there is no principle of patent law such that the examining division had set out as summarised at the end of 3.11.
It is a helpful passage in the paragraph you just took us through a moment ago.
Yes.
On 2298, the first complete paragraph. If one goes halfway down,
Yes.
they say the present application is not concerned with the problem of obtaining a finite set of particular products. The character of the invention this time is one of general methodology, which is fully applicable with any starting material. And then jumping to 3 lines down, 3 lines from the end, as long as the system works reliably at every stage, there is no obligation to exclude future starting materials.
Well, of course, I accept all of that, but again, I emphasise each of these cases is concerned with particular facts, but I'm seeking to identify in the passages that I've cited the general principles that the Board of Appeal is recognising, and those were the principles which Lord Hoffman understood the Board of Appeal to be stating in the Biogen case, and the principles are those that I have identified. Mr. Speck is going to deal with each of these cases and assist the court in relation to the particular facts and the particular science involved in each of them. I should also mention that in their written case, Kymab responded to our reliance on Genentech by suggesting, and it's, don't invite the court to turn it up, but it's paragraphs 120 to 122 of their written case, MS 98. And it was also in their application for permission to appeal to this court, paragraphs 9 and 10 on MS 32. They suggested that there might be a distinction between two classes of embodiment, those that could be envisaged as at priority date and so needed to be enabled on their approach, and those which might be invented in the future, but which did not need to be enabled as at priority date in its view. My friend did not develop that point yesterday. He didn't suggest that Genentech is confined to the first category, and in my submission that would be an approach entirely inconsistent with the principles that have been set out by the Board of Appeal. It's not a distinction that appears in any of the later cases. It would make no sense in policy terms, and it would be a test inherently uncertain. How prescient would the skilled person have to be in identifying whether something was or was not within contemplation at priority date? But my friend hasn't developed that point, and so I say no more about it. The Genentech decision was then followed by the Board of Appeal in the microorganisms case. That's tab 32. And the Board of Appeal stated at 2316, paragraph 3 at the bottom of the case, that the applicant had submitted that certain strains were not available to the public during certain periods of time after the publication of the present application. And the board dealt with that over the page. It's a brief decision. They dealt with it at 2317. However, the board has held in its decision in Genentech that an invention is sufficiently disclosed if at least one way is clearly indicated, enabling the person skilled in the art to carry out the invention. Then the non-availability of some particular variants is immaterial to sufficiency, as long as there are suitable variants known to the skilled person through the disclosure or common general knowledge, which provide the same effect for the invention. So again, we see that the Board of Appeal do not consider that it is always necessary to show that the claim can be enabled across its entire scope, and a relevant consideration in that respect is whether or not one has a general principle in terms that the same effect is going to be seen across the scope of that which is claimed.
This is another case where the claim is in respect of a process. One sees that in paragraph 1. And, so it's the same point, really, that provided the process is shown to work, it doesn't matter that not every conceivable substance to which the process might be applied has been tested or even exists.
But to draw such a distinction, in my submission, serves, with respect, no sensible purpose if one's looking at the principles of patent law, if one's asking the question, what is a fair recognition of patent protection, which is what Genentech requires. The policy considerations cannot depend on whether one defines the particular claim as product or process. Far less can, in my submission, it be sensible to do so when the product, in this case, is a product defined by reference to particular characteristics which involve something being done to the mouse. I mean, it makes no sense in my submission to say that if it's a process claim, of course, one would recognize where there's a general principle where it has the same effect, that it's not necessary to show as at priority date that all embodiments can be made. Once one recognizes that in a process context, why not in this type of product context? Again, each of these cases is very much dependent on its own facts, but we say there is a principle that comes through here. The enlarged Board of Appeal, as has been mentioned, has briefly referred to this matter in the transgenic plant case, this matter being the Genentech decision. It's Authorities Volume 5, tab 42. And the context here was whether claims could comprise plant varieties without identifying them. And the enlarged Board of Appeal at MS 2614, page 18, in the middle of the page, say a similar situation concerning the requirement of sufficient disclosure in Article 83 may be found in the case law concerning biotechnology inventions, and in decision T361, that's microorganisms in Nabisco, it was decided the non-availability of some particularly effective strains in a class of microorganisms is immaterial so long as other suitable strains are available to the skilled person. This meant that a claim directed to the use of the whole class of microorganisms could be granted although specific strains complied in this class were not available to the public. In other words, although specific embodiments covered by the claim could not be carried out, the claim was held allowable. See also Genentech. Hence, the anomaly assumed by the referring board does not exist. Rather, the examples show that the rule assumed by the referring board that an invention is not patentable because it covers an embodiment which does not fulfill the requirements for patentability is not without exception. Therefore, the answer to the question which interpretation is the correct one, and it's which interpretation of Article 53, has to be given in the light of the context as well as the object and purpose of the provision. So we rely on that. That's approval of the Nabisco and Genentech principle from the enlarged Board of Appeal. That's, of course, the EPO Senior Tribunal hears appeals from the Board of Appeal where there's important points of law arising. It only sits a handful of times a year. It comprises members of the technical boards of appeal and national judges from contracting states. So we draw attention to that. We say that, again, is entirely consistent with our approach. There's another case to which Lord Justice Kitchen referred at paragraph 228 of the Court of Appeal judgment, but it might be better just to look at the authority. It's Authorities Volume 5 at tab 37. This is the Kirin Amgen case. It's the same patent, isn't it? Yeah, we think it's the same patent as was subject of consideration by the appellate committee, but that doesn't matter. The point that's being made by the Board of Appeal appears at MS 2454, paragraph 4.5, where the board say this: for the board, it is a fundamental principle of patent law that a claim can validly cover broad subject matter, even though the description of the relevant patent does not enable every method of arriving at that subject matter to be carried out. Otherwise, no dominant patent could exist. Each developer of a new method of arriving at that subject matter would be free of earlier patents. In many cases, in the field of biotechnology, patent protection would then become illusory. This is not to say that some claims might not be too broad in scope and not be enabled over their whole scope for the purpose of Article 83. And they refer to T409, which is fuel oils Exxon, and they refer and another case, which is Mycogen. But this was not considered to be the case in respect of Claim 1 by this board. On the evidence before the board, this is res judicata. The boards have considered this question of allowability of a broad claim versus the requirements of Article 83 strictly on a case-by-case basis. And we respectfully agree that's what they're doing. Influenced by the extent to which the information in the patent could be used to develop further embodiments without a major conceptual leap. And that's the question. The question is whether or not the inability to be able to make as at priority date each embodiment is in a context where the use of the inventive contribution by the later use would involve a major conceptual leap. And our case, as I've repeatedly said, is that to use the reverse chimeric locus for larger quantities of DNA does not involve a major conceptual leap. It is to use the invention the technical contribution that we have made. The question of the allowable width of claims in relation to sufficiency under Article 83 may be an important question of law, which may at some stage have to be considered by the EBA. Well, it has been. I've shown the court that reference in the light of recent national case law, which shows that the view of some EPC contracting states' national courts may not be the same as that expressed here. And they say CF, House of Lords in Biogen. It's not clear to us what they mean by that, but there is a reference to that. So we rely on that authority as well in supporting our position.
Is there a synonym or an explanation of what is meant by a major conceptual leap in the terminology here used?
Well, not in this decision.
No.
No.
But is
And
it
I'm not
something more
aware.
widely used?
Well,
Is
I'm
the
not-
term
I'm
more
not-
widely used by the technical board?
Well, I can't cite other cases. If those next to me are aware of other cases, I don't think they are either. No, but what it does is it recognises, and this is, I hope, consistent with all the submissions that I'm making to the court, that this is a very difficult question which needs to be addressed by reference, as the Board of Appeals has repeatedly said in the authorities that I've cited, needs to be addressed by reference both to what is a fair allocation of patent protection and what is the technical contribution that has been made. And it is not a question to be answered merely by saying correctly that what we have disclosed does not enable the skilled reader, as at priority date, to make every mouse that falls within the scope of the claim. That isn't the test. Now, what the Board of Appeal have said doesn't provide some scientific means of answering the question, but it provides the principles which are consistent with the principles for which I have contended that should guide analysis in this area. That's the way I put it.
I wonder if major conceptual leap means any more than, or without major conceptual leap means any more than without undue burden or inventiveness, which is, I think, the phrase one sees more frequently in other cases.
Well, it's not saying, is it, that in my submission, it's not saying that any inventive step would suffice, because here one is contemplating that it may well be the case that those who discover a new way of inserting a quantity of DNA into the mouse will have invented something. So that can't be sufficient, because that's the whole context of what is being said by the Board of Appeal recognises that there is a foundational invention in a case of this sort, which is built upon. The question is whether or not it is open to the person who comes along and who says, I can now insert greater quantities of DNA into the mouse, whether our patent is valid, because what they are using is the conceptual leap, the very substantial conceptual leap of our technical contribution of the reverse chimeric locus. That's what they are using. So that's that case. I'm going to leave to Mr. Speck fuel oils and Exxon, which is relied on by my friends. And I'm going also to leave to my friend's Detergents Unilever, my friend Mr. Speck, Detergents Unilever, which was also relied upon by my friends. But there is one other authority that the court may find it helpful to take into account in relation to the issue raised in this case, and that's the decision of the German Federal Supreme Court, of which the court has copies. It's not in the bundles. It's a decision of 2013. And it's the Federal Supreme Court, 10th Civil Division of Germany. There's a headnote that summarises what's going on here. The applicant is generally free to choose not to limit the claim. Does the court have a copy? I'm grateful. The applicant is generally free to choose not to limit the claim protection to embodiments that are expressly described in the documents originally filed, but to make certain generalizations, provided this takes account of the justified concern of capturing the invention to its full extent. Whether or not the wording of a patent claim that contains a generalization meets the requirement of an enabling disclosure depends on the protection it seeks, which must not go beyond what the skilled person, taking into account the description and the embodiments contained therein, understands to be the most general form of the technical teaching that solves the problem underlying the invention. A description of a group of substances in terms of their function in a use claim is not precluded by the fact that such a wording of the patent claim also comprises substances which will not be provided until in the future, in addition to substances that are known or disclosed in the patent document, nor by the fact that their provision may require an inventive step. And if we turn, please, over the page, paragraph 1, we see that the legal predecessor of the patent proprietor had filed a patent for the use of effectors for lowering the blood glucose level. And there's a bit more detail about that over the page. Paragraph 6, the patent in suit concerns the use of certain substances for lowering the blood glucose level in mammals. It was known in the art to administer insulin for influencing a pathologically increased blood glucose level. The description of the patent in suit states that previously known methods were associated with a great deal of effort, high costs, and usually a drastic reduction in the quality of living of the patient. More modern methods, such as the installation of depot implants or implantation, are technically difficult and risky. Against this background, the patent in suits relates to the technical problem of providing a simple, cost-effective method for lowering the blood glucose level, which is not too burdensome on the patient. Then they deal with the issue which concerns this court at paragraph 18. They say a generalizing wording in a patent claim violates the requirement of a clear and complete disclosure if it generalizes what is protected by the patent beyond the solution according to the invention which is disclosed to the skilled person in the description. And there's a lot of case law then cited. And then 19, subject to this, it may be admissible to recite a group of substances in a generalized form, even if not all substances that belong to this group are suitable for the purpose of the invention, provided the skilled person is easily able to determine the suitability of the individual substances by experiments. Thus, a claim worded in this manner also covers substances that do not yet exist or that have not been discovered yet, is no cause for concern. As long as using them makes use of the invention, it is not problematic that substances are also covered that cannot be found without an inventive effort. It is in line with the principles set forth above that according to the case law of the Board of Appeal of the EPO, the choice of a functional feature is admissible if the generalization thus entails takes account of the justified concern of fully capturing the invention. And they cite cases which include Genentech, modifying plant cells mycogen. They refer to Biogen, and they refer to the earlier Court of Appeal judgment Regeneron and Genentech at MS 1858. This is not opposed by the functional description of the feature comprising the use of options still unknown that may possibly not be provided or invented until in the future, if that is the only way adequate protection can be obtained. See Genentech. In such a case, the invention is generally already sufficiently disclosed if it shows the skilled person at least one way of how it can be carried out. The requirement of clear and complete disclosure does not require the description to contain indications of how all conceivable variants of the components which fall under the functional definition can be obtained. See Genentech. If such a demand were to be made, a generalizing wording of the claim would regularly fail because of the requirement of a clear and complete disclosure. Whether or not a claim wording that contains a generalization is admissible in the individual case therefore depends on whether it seeks protection that goes beyond what the skilled person, taking into account the description and the embodiments contained therein, understands to be the most general form of the technical teaching that solves the problem underlying the invention. And we rely on all of that. We rely on it for the proposition that it is not necessary where you have a general principle. It's not necessary to show that each application is capable of being made at priority date. It's sufficient, as they say, if enough has been disclosed with general knowledge to enable the skilled person to work to produce one embodiment, provided that looking at the invention as a whole, the skilled person can be satisfied that it is going to work in all embodiments, and even though, see the end of paragraph 19, even though some inventive effort may be required in order to apply the invention to these other embodiments. And furthermore, and this was a matter that my Lord, Lord Briggs was asking me about, you also look at what is the problem underlying the invention, paragraph 21. You don't, in my submission, you don't simply look at the claim in isolation from the problem which it is seeking to solve. So we rely on all of that as a recognition by the German Supreme Court, essentially, of the principles for which we contend.
I'm right in thinking, aren't I, that this is another case where it's patenting a process for the achievement of a certain therapeutic effect by the use of non-patented input substances. Well, they may be patented, they may be subject to other people's patents, but the patent isn't seeking to patent the input substances.
Well, it's seeking to produce a result. It's seeking to ensure lowering of blood glucose levels in the afflicted patient.
And that's the heart of it.
Well, indeed, but my submission is that one can't, one shouldn't, in my submission, one shouldn't adopt the approach that one can identify two different categories of patent claim, one that's product, one that's process, and recognize that the patent law, both here and in the EPO and in Germany, has wisely recognized that there are cases where, by reason of the generalized nature of the technical contribution, it is not necessary for the patentee to show as at priority date that all embodiments that fall within the scope of the claim can be made. But that doesn't apply to product cases when the reasons why the courts and the Board of Appeal have adopted this approach in relation to process is because of the wish to ensure a fair measure of protection for the technical contribution that has been disclosed, and because of the adverse consequences in policy terms that will follow if the law doesn't adopt that approach. And I do submit it would be a very strange result to say that if one categorises the claim and the technical contribution as process, a different result follows from if one categorises it as product, particularly in a context such as this, when the product is a mouse with particular features that are the result of a process being applied to the mouse in its natural state. So my submission in support of the Court of Appeal's conclusion is that the law of sufficiency under domestic law and under the Board of Appeal's decisions requires the court to focus on three matters. It requires the court to focus on the content of the claim, the technical contribution which is made to the art, and whether there is sufficient disclosure to allow the skilled reader to make the product as at priority date in one manifestation, but it is not necessary to show that each embodiment can be made. The requirement of enablement does not so require. What is required for an enabling disclosure depends on the context, and it particularly depends on the content of the claim and on the technical contribution. And here there is sufficient enablement because the claim is to a product defined by reference to specified physical characteristics. That makes a technical contribution to the art. The mouse could be made as at priority date. There is a general principle applicable here in that every mouse within the scope of the claim will have the same effect. The law of sufficiency does not require more than that. The claim is commensurate with our technical contribution. To adopt Kymab's approach would frustrate the policy of patent law. Those are the submissions I want to make. Mr. Speck, as I say, will add to those.
Thank you very much, Lord Hennig.
My lady, as my learned friends indicated, my task is basically twofold: to explain the scientific innovation at the heart of the patents in this case, and to cover, in particular, the EPO domestic case law, where a little bit of an explanation as to the science is needed to understand what's going on in those cases. And in particular, it's not limited to, but the two cases that my learned friend indicated that I would cover, exon and detergents. But to give some structure to what I'm going to address, I would like to spend just a few minutes identifying what I'm hoping you'll keep an eye on as I cover these matters. You've heard a lot about what I call the golden rule of patent law, which is that the patent monopoly must be justified by and be commensurate with the technical contribution disclosed by the patent. The technical contribution will be found in or result from the technical effect of the combination of features of a product or where the invention is a process of that process. It may, depending on the facts, exist as something that is specific or general. And a really important point to grasp in my submission is that a key task of the court in patent cases is to identify the technical contribution at its appropriate level of generality. Sometimes it will be a principle of general application. Indeed, it often will be a principle applicable at some level of generality. That's, after all, why we have detailed embodiments in a patent with more generally framed claims. That's what's going on there. Now, my learned friend, Mr. Purvis, has highlighted, when we talk about a principle of general applicability, we could be talking about a general principle simply as an element or integer of the claim. For instance, the fixing means example that he gave as being a way to cover the requirement in an invention where two different parts are to be connected. That is its most basic form and is an example where the principle is simply being used by the invention, in the sense that the principle doesn't tell you anything about the overall invention as a whole, simply that those two components can be fixed by any suitable means. Now, a principle of general application can also be a principle that is generally applicable to any product with the overall combination of features of the whole claim. There, it's not a principle that's being used, it is a principle that one can see as embodied in the product. And usually it's because a combination of particular features gives a particular technical effect. For simplicity, I'm just going to concentrate on explaining this in the context of products, but what I'm saying applies to methods described with particular features identified as well. In the case that I've just described, the principle of general application is not merely something that is used by the invention, but it is the technical effect of the overall combination of physical features. In other words, the technical contribution of the invention itself. And in such cases, the question that arises is typically how general a technical principle has been contributed by the patentee's disclosure. When it comes to the insufficiency objection, that is highly sensitive to the nature of the invention. I think my friend Will Panic showed you a statement to that effect in Kieran Amgen. I'll just give you another one without asking you to turn it up. It's Lord Justice Floyd, paragraph 39 of the Annan case, which is in Authorities 1, tab 2, MS 812, and it's the last sentence of that paragraph. And what the case is on insufficiency, and in particular those concerned with claim breadth, are at their heart about is this: whether or not the patentee is attempting to claim something that is not the disclosed technical contribution or is not commensurate with it. That is the heart of what we're grappling with. And so the point of me going to the detail of some of the key cases will be to see, or for you to see, what was actually in issue there. And I would also add this: the cases are regularly, in reality, concerned with the question of whether the monopoly being claimed has been generalized out so as to try to claim some already known or obvious goal. What do I mean by that? Let me illustrate it with an easily recognizable example, or one which I hope will be. The heavier-than-air flying machine, a well-known goal at the end of the 19th century. The Wright brothers devised one, and they were the first to do it. I think it was in 1903. By do it, I mean achieve the goal. But they could not have claimed all heavier-than-air flying machines, covering, say, a modern-day rocket or a helicopter, even covering machines that us sitting here today can't envisage yet. But Orville and Wilbur Wright may have been able to claim a patent monopoly to a generalized description of their flying machine, perhaps focusing on the structure incorporating fixed wings extending from either side, where the wings have that well-known cross-sectional shape to take advantage of Bernoulli's principle to give the required uplift. One could readily envisage a claim which is a generalized description of the actual embodiment they made, framed to reflect that general technical contribution. And as such, that monopoly would be perfectly good, and I would add fair. Everything within such a claim, everything covered, is a way of implementing their technical contribution, even though they'd only enabled one very basic embodiment. I think one where the man had to lay on a tray and steer with his feet, I think, but it was a very basic embodiment. But their claim would legitimately cover all improved embodiments, perhaps with improved wings where the flaps enable the uplift to be controlled, or for the pilot to enter a banking maneuver. And it could cover embodiments constructed so as to use a different manner of generating propulsion, including those that made it possible to fly further and much faster. So, covering the brothers' principle when powered by Sir Frank Whittle's jet engine when it came along. But simply claiming all heavier-than-air flying machines is not a claim commensurate to the actual technical contribution disclosed. It's not a technical contribution at all, just a previously known goal. Now, the earliest case that I'm aware of this kind is the famous and very early case concerning Samuel Morse of Morse code fame, and it's touched on in Lord Hoffman's judgment in Biogen. Can I just show you that? It's Authorities Bundle 1, tab 5, and the MS page for the reference is MS 982, and it's dealt with between lines 10 to 22.
Well, this is one I was thinking of, but I was misattributing the invention to Edison.
I thought you might have been.
Yeah.
But you see the issue encapsulated by Professor Chisholm in the quote at line 19. And the crucial thing about the point I'm making here is not just that he was trying to claim all ways, but he was trying to claim all ways of doing something that others appreciated the possibility of achieving. It was a known goal. And the cases are often about that. And that's why it's absolutely crucial when you look at the cases and you read statements, one or two sentences, that you actually understand what was an issue and what the patentee was trying to do. I'm not sure I'll get through the next point I want to flag up before 1 o'clock.
Yeah, well, if that's a convenient moment, we'll adjourn then until 2.
And that is it for today, ladies and gentlemen. We'll be back here tomorrow with part 4 and then the judgment on this. So please have a wonderful rest of your evening. I will see you guys tomorrow at 3 o'clock p.m. Central Daylight Time. If you like the content that's on this channel, please consider subscribing to this channel and helping this channel grow. If you like the content that's on this channel, please let me know that you like the content. But I'm going to leave you guys until tomorrow afternoon at 3. You all have a wonderful evening. Ta-ta and ciao-ciao, and I will see you again soon.
Breakdown, you're the one I call. From the mountains high, come down to it all. With your tools in hand, making magic flow. Every broken part, you help me grow. You fix it all, you fix it all. Daniel, you make it right. Daniel, everything's right. When I'm falling apart, you put me back together. Daniel, you make it better. From the wires tangled up to the broken dreams, you know how to mend all my scattered seams. With your steady hands, you refill my heart. Every piece that's lost gets a brand new start. You fix it all, you fix it all. Daniel, you make it right. Daniel, everything's bright. When I'm falling apart, you put me back together. Daniel, you make it better. Fix it, Daniel, fix it, Daniel, make it right. When the world shuts down, and I can't see clear, you're my solid ground, always drawing near. Never give up on this heart of mine. Put it back together every single time. Fix it all, I will stand tall to all you do. From the highest peak, I can see it through. With your care and touch, everything's okay.